Thank you, Madam Chair. And I know many people have been waiting for this particular amendment, and it come up to me quite frequently today, and I was hoping that we would get to it earlier. But in any event, here we are. It's the last amendment to propose on my behalf. I'm sure you're all excited about that. But I have to tell you that this particular amendment does something that's very, very important. What it actually is trying to do is restore what I think the governor's bill had as being right on target. There is provisions in the governor's bill that you have heard had been omitted. One had to do with wire tapping type issues, and the other one had to do with gratuities. This is the gratuity amendment, and it is about an amendment in which many people on the governor's task force thought it was very important to reconcile incongruences with existing statute. And I think that's important for all of us to know that when we're taking a vote on this today, it's going to be doing something that I think is very important. What it's actually doing is looking at the gratuity statute, which is chapter 268A, section 3. And the reason why this is an important provision that was omitted from the governor's bill is because that it not only clarifies and offers congruity with regards to the gratuity statute and the conflict of interest statute, but it does so for all government employees, not just elected officials. So don't think this is just about you folks. This is about all government employees. So it's important to quell a couple of the misconceptions that have been put around this. It's also important, I think, for us to pay attention to what potentially could be compromise language that has, I think, an ability to be even more restrictive and to create a higher standard of burden to be able to prove. But in this case, this reconciliation has to do with gifts, gift giving, and gift givers. Why is the statute change necessary and important? First, the section that I had expressed at the beginning, 268A, prohibits persons from giving to government employees and also government employees from receiving gifts of substantial value for or because of any official act performed or to be performed by such an employee. The Supreme Judicial Court had a decision. Many of you heard about that decision that had been rendered, the so-called Scotia decision, which had been interpreted the gratuity statute in a manner that was pretty much akin to the bribery statute, which required a direct link between a gift given and a specific official act in order to be considered a violation of that section. However, under the SGC decision, gifts that were given to influence an unspecified official future conduct or act that might not directly be linked to the specific act would not be covered. Simultaneously, in current statute, the conflict of interest statute, which is 23B section 2, actually prohibits all government employees from using their official position to secure unwarranted benefits. So where's the rub here? Well, an employee who is accepting a gratuity that under the SJC decision doesn't violate the gratuity statute as defined by them may nonetheless actually violate the conflict of interest statute if the gratuity was given just because of the employee's official position. So you see, one is linked to the conduct or the official act, and the other one can grab you just for the mere sake that you are in an official position. So what the governor's version actually did, and was tempting to do, is to make sure that those statutes are reconciled with the requirements that are set forth for violation in each one of those. Why is this important? Well, first, it makes sense that in all cases in which a government employee is prohibited from receiving a gratuity, the private citizen is likewise prohibited from giving it. That's one of the first things that this does. The second thing it tries to do by reconciling these two amendments is it protects government employees from confusion and making the wrong decision or mistake of believing that because of a specific gratuity or gift, it's not given for or because of an official act, they can accept it. And it can always be accepted. And therein lies the trap, because you might, by one ruling, be considered off the hook. On the other, you are actually mandated by another statute not to be able to accept it at all. So the government bill actually seeks to prevent not only penalizing the receipt of things of value in cases in which there's no genuine risk or conflict, because the other aspect of this provision in the governor's bill and also in ours looks to do that, but it also is trying to minimize or prevent conflict of appearance or the what we consider to be conflict of establishing regulations to specifically exclude certain circumstances. So if you were looking at this and said, okay, what am I trying to do here? I think what you're going to hear about is that there may be language that's offered that will go to the next level that I'll speak to later, but this amendment actually improves our understanding that receiving gratuities of a substantial value, which is going to be defined in the law, and we all accept and agree on that piece of it, but it's not an exception if you're a government employee and you don't have to reach the bar threshold to prove that was for an official act, because right now under the conflict of interest statute, just to accept it is in violation. So this is one of those proposals I really think we need to be concerned about, and it's one of those that I again say we shouldn't be ruling by the exception, but should use the existing statute and make them congruent so that we don't wind up with people thinking they're safe on one side and can do something and the burden of proof is much higher, as opposed to making sure that our statutes on all levels with gratuities and gift giving are the same. Having said that, there's one other part of this bill that the governor put forward that is really important, and that is that the gift giver themselves is also held accountable and has the burden to be responsible for having given a gift. In the past, it's only the recipient. So that is another important provision. So I would like to ask you to really seriously consider the necessity of making sure these two statutes are not in conflict with one another, and making sure that we provide congruence so that government employees on one hand aren't being tagged with violations while others are being let off. And even if you're let off, you may still be found in violation of the other statutes. It's really good government. It's good, I think, to be able to reconcile the incongruence, but more importantly, I think what we're trying to do is send a message loud and clear that we're not going to allow loopholes to continue to exist when people have, as government employees, accepted gifts of substantial value, because that is not our primary role. It should not be a role at all that we should be concerning ourselves with. Nevertheless, we have statutes that need to be remedied and need to be brought into congruence. And Madam Speaker, when you call for a roll call, a vote on this, I ask for a call for the yeas and the nays. Thank you.